We're back. Beautiful day. Great to be alive. Had a couple of crackers and a little Hershey piece. Guess we're ready to get back to work. Hope it's good wherever you are. Even if it has to be California, I hope it's good. And so I'm going to close this out. I've already got about 6 or 8 people in the waiting room, and we got a lot more to do. So I buckled up. Here we go. Trick is to remember what a privilege it is to have this job. Some days it's harder than others.
Good afternoon.
Good afternoon.
I see we've got the Bakers for our one.
Yes. Mr. Butler, are you here on Dort Financial?
Yes, I am.
I've got JDGI. Mr. Goodwin, is that you? JDGI. Who am I speaking with? What's your name?
Goodwin. It's Cody Goodwin. Sorry, I didn't know my mic was muted.
Let me give you a proper name here. Andrew, the clerks didn't think I had enough to do, so they stuck a general civil matter in here at 1.
Hey, well.
So we'll deal with that matter first.
Thank you.
This is file number 251027GC. It's entitled Dort Financial Credit Union versus Cody Goodwin and Caitlin Fox. Cody Goodwin is here on his own behalf. Attorney John Butler is here on behalf of Dort Financial. The defendant filed a motion in handwriting to set aside the civil default that entered in this case. That says, I, Cody Goodwin, failed to respond because it wasn't clear to me my wife and I counted as separate parties. So I assume this response written in her account accounted for both of us. However, I am in agreement with a payment plan that is currently in set. The default entered on September 4th in the amount of $2,528 in damages, as some payments had been made. Defendant filed this motion on October 13th within 21 days of the entry of the default. Plaintiff filed a response objecting to it and or agreeing that if we set aside the default, it'd be conditioned on paying reasonable attorney fees for setting it aside. But there is a repayment agreement in place that the defendant apparently agrees with. Mr. Butler, what's your position?
Judge, it's twofold. Number one, I don't think there's good cause of meritorious defense or an affidavit of facts. But two, I'd like to keep the judgment, but he and his wife can pay the way they are, and that's going to be satisfactory.
All right, Mr. Goodwin, you're not an attorney. And I don't expect you to necessarily know all the rules, but there is a rule regarding a motion to set aside the default. In order to grant that, you have to find good cause for failing to appear and a meritorious defense. So I'm not sure we have either of those. You didn't answer because you thought your wife's answer sufficed, but you don't have a meritorious defense. You acknowledge that you owe the debt and you're in a repayment plan. But you're in agreement with the terms of the repayment agreement with your wife? Is that correct?
Yes, sorry.
What are the terms?
That I will pay back the X amount of dollars I owe back of $160 on a money order every 18th of every month or 14th. I can't remember, but I send it out the first week of every month.
Does that sound correct, Mr. Butler?
Yeah, it was 80 for 3 months, and then starting in October, it was $160 per month. And so long as the payments continue, other than a state tax guard, the plaintiff doesn't intend to take any other collection action. I just don't want to lose the default judgment.
All right. Caitlin Fox. All right, Mr. Goodwin, your motion is denied at this point, but you agree to continue the repayment agreement with co-defendant Caitlin Fox, and they won't pursue any wage garnishment for either of you. They are eligible to pursue a tax garnishment from your Michigan tax return to help pay this off sooner. But at this point, the judgment is in place. You acknowledge that you owe the money. You're in a repayment agreement. And I don't find a meritorious defense. So there's no need to set it aside. We'd set it aside and then you'd enter into the same repayment agreement you're already in. So the motion to set it aside is denied, but you'll continue to comply with the repayment agreement with your co-defendant, Caitlin Fox, and that should resolve the matter. Are you still at 525 Centerville Street?
Yes, sir.
All right, just continue to make the payments that you're currently making now.
Okay. Right.
All right, Mr. Butler, thank you for being here. I'm not going to order any additional attorney fees. I'd like to just get this paid off. They can't garnish your wages, but they could garnish your tax refund, so your state tax refund. So be ready for that.
Okay, that's fine. We
All right.
kind of plan to pay it with that anyways.
All right, Mr. Butler, anything further we need to put on the record here?
No, Your Honor. Thank you very much.
All right, thank you. We were able to take care of that in 9 minutes. That's all right.
Thank you very much.
All right, Mr. Goodwin, good luck to you. He's gone. Now I've got Samsung logged in. Who am I speaking with? Your phone's on mute. What's your name, folks?
We're Jeremy and Brandy Baker.
All right. Let me give you a proper name. And the Lerns are here. This matter is set for 1:15, but everybody is here, so we might as well just get down to business. All right, everybody is here. Mr. and Mrs. Learn are here and the defendants are here. This is a land contract forfeiture action. The file number is 252017. The attorney previously known as Andrew Rognus is here for the plaintiffs, and Mr. and Mrs. Learn are here and the defendants are here. Mr. and Mrs. Baker, would you unmute your mic? The law requires that I advise you of your rights as a tenant in a landlord-tenant proceeding. This is a possession for premises. It is land contract, but the same rules apply. You have the right to hire an attorney. If you cannot afford one, the county would give you information regarding a legal aid attorney, or you may be able to seek other legal advice. I think our legal aid attorney is going to be with us today. We're a little early. You have a right to have the case heard here in St. Joseph County where the property is located. You have a right to demand a jury trial. If you wish to have a jury trial, you must tell the court at this first appearance or make the demand in writing within 5 days of today and use the jury demand form MC-22 and be prepared to pay the $50 jury demand fee unless the judge waives it for your inability to pay it. If your landlord has asked you to be evicted from a residential property because you haven't paid rent, this isn't that kind of case. This is a land contract forfeiture case, and I don't believe there's any emergency funding for that purpose. You may be able to reach an agreement with the landlord by going through a mediator, and if both parties are interested, we can set that up. And if the matter can be resolved, it could result in the filing of a conditional order of dismissal. I have my face page on here. Anyway, this is a land contract. It's alleged to be in arrears. I wasn't completely clear on the status. I lost the first page of my stuff. What it looks like, this is the property on West Michigan Avenue where the adult foster care home is.
Correct.
Is that correct? All right, original selling price $250, principal balance due $1,910.
That's
Mr.
not
Agnes,
correct,
what's
sir.
the status here?
That's the arrearage, the balance due, since the last payments in July, 197,666.64, so less than half has been paid. So
All
that
right.
with a 90-day redemption period.
All right, Mr. and Mrs. Baker,
Yes.
apparently you've paid substantially on this, $50,000 or $60,000. It is a land contract. The rules are different with a land contract. You have more time. If less than 90 days, if less than 50% of the purchase price has been paid, you have 90 days to redeem it. That means get it caught up. If more than 50% of the purchase price has been paid, you have 180 days, but we aren't in that circumstance. The law also requires that I adjourn this matter at least 7 days for you to get potential legal counsel or legal advice. What's your plan? Do you plan to try to bring this contract current?
We do, actually. We were in one of those situations where when it rains, it pours, and we just had one after another after another. In fact, hopefully during this whole thing, I've been trying to, I apparently, they stopped by, one of them stopped by the house one day. I wasn't home. I don't know if there's a miscommunication with phone numbers, but apparently they've been trying to reach me. I've been trying to reach them. I'm not quite sure what's going on. So, but yeah, our plan is to get caught back up and continue on as usual. We just, like I said, we had some bad things happen.
Well,
All right,
maybe
Mr.
if
Rognus.
they've got a pencil, Your Honor, they can write down these numbers.
All right, well, let's figure out what the current arrearage is right now.
Correct.
How much is that, Andrew?
$3,900 for November. If it goes beyond November, it's a $995 each month after that. There are costs, $196.75, and there's unpaid taxes, which is accruing penalty and interest. They're currently $3,709.27. So I'm not certain what that all totals up to, but it's probably somewhere in the neighborhood of about $7,500.
All right. Do you have clients in the property?
We live here with our family.
Oh, it's just your house. It's not a rooming house anymore?
It used to be, and we bought it and we just turned it into our
Okay.
home for our family.
Good for you. It was a very fine home at one time. It was one of the finer homes in town 100+ years ago.
Yeah.
Yeah, we were very excited to get in here. We put a substantial amount down. We did a lot of gutting and redoing and getting it, back up to where it needed to be. And that's when something went wrong, and it was just one thing after another. And we've been playing catch up ever since.
All right, well, let's talk about first thing we need to do is we have to continue this matter for 7 days, unless you're willing to just acknowledge the terms of it. But if you wish to review it or get legal advice, we have to continue it for 7 days.
Yeah, I tried looking into legal advice. I've been having some medical issues as well. So I will continue to look into legal advice. But like you had said, with this being a land contract as opposed to a traditional mortgage or a rent situation, getting assistance is a little trickier, I guess you could say. So I'm
Well,
still
I don't think they
working on
give
it.
you assistance for a land contract, so
No.
maybe some. B14. Next week we're full from morning to night. 9, 9, 10, 9, 29, 30. All right, we've got,
Want to throw it over the 17th?
how about 10? No, it'll be fine. Are you available at 10 o'clock
Yep,
on Friday, November 14th?
yep. And
All
did
right,
you get those numbers, Mr. and Mrs. Baker?
Yeah, I thought I had it. I'll write it down again, but I thought for sure I had the correct phone number.
No, did you get the numbers though?
He's talking about,
Oh, yeah.
3,900 through
Okay.
November, 196.35 in costs and unpaid taxes of 37.05. And it's better to do this sooner rather than later. But if we add all that up, it's close to $8,000.
Yeah,
390.
I think Monroe or Vicky had stopped by the house and talked to Jeremy. So hopefully you guys can exchange phone numbers. Don't do it on the Zoom feed because everybody in the world hears it. But, you
Yeah.
guys can, exchange numbers and talk amongst yourselves.
Yeah. Can I ask just real quick? I sent a text to Monty. Did he receive that text?
I don't think so, hun. And I really like you guys, and we would really like to work this out. But at the same
Yeah.
time, we just want to just try to figure it out. The cost of my medications and all that.
yeah.
Oh,
So-
no, I know. And we want to work this out too. I was kind of hoping maybe you can stop by one day. We'll set something up, have dinner. We'll kind of go over everything. We'll get back on track.
Even after next week, you get 90 days from next week. So you got time to try to work things out, at least
Okay.
97 days. But we're going to continue it to next Friday morning, November 14th at 10 a.m.
Okay.
All right, thank you.
Thank
Any
you.
questions? Mr. and
Thank you,
Mrs. Byrne,
guys.
thank you.
Thank you.
We got a
Okay,
head
yeah, have
start.
a great day. Bye-bye.
All right, very good. All right, Which one was this? There's my face sheet. Hello, Howard.
Good morning or afternoon.
Why won't it let me leave?
I'll get you out, Miss Baker.
Thank you.
Hi, Howard.
Hi.
Now, we had a 115, which I think resolved. So our next matter is no, that was our 115, our 125. I've got somebody named Jamie. That'd be Mr. Kreitz. And we got Matthew Farmer, who was served by attachment. While we're waiting, Howard, let's talk about the numbers here. This is
Okay.
filed as a non-payment of rent. What's the
And
current
basically,
status?
the defendant has moved out. He's gone.
What do you wish me to do?
Pardon?
What do you wish me to do?
I'm not sure exactly when he left, but he has left, and where
Well,
he's
how much,
gone.
this is filed as a non-payment of rent. He was served by attachment. So let's see, if we have a second mailing, I can do a default, but I don't think I do. So in the meanwhile, it's sitting empty, but I can't
Yeah.
do a default without service.
I'm almost tempted to say, could we just dismiss it?
Yes, you can do that. Here's Diana.
Uh,
Then you just,
obviously, we wouldn't get a judgment, but if he's split the area, finding him is going to be.
good afternoon, Miss Lamont. We're at
Hello,
Lamp and Key
gentlemen.
versus Matthew Farmer. And according to Mr. Bush, it appears the defendant has vacated and the property's empty. Did he leave any information?
No, last I talked to him, he was in Costa Rica.
Hmm. All right, well, if you want the court's imprimatur, we have to adjourn it and wait 10 more days. If you want to just dismiss it and then take possession of it on your own regard, that may make more sense. So,
Yep.
Mr. Bush, you just wish to dismiss?
I would ask Diana, is that agreeable with you to simply dismiss this and go from there?
That's fine.
All right.
I
Yes.
mean, finding him is going to be difficult.
Well, Costa Rica is probably a good place to be in November. But I find plaintiff moves to dismiss. Defendant has vacated. Yes. Well, if you wish to collect, Howard, maybe you can go down there and see if you can find him.
That might be interesting.
Judge Welty was a big fan of Costa Rica. My sister lived there for several years. I haven't been there, but I've been to an island about 50 miles away. All right, we'll call that a hearing with default and a motion to dismiss. And thank you. You're good to go. Hello, Mr. Kreitz.
Hello, Your Honor. How are we doing on Friday?
We're doing
Okay, thank you.
all right. All right, Mr. Bush, I'll remove you. Jamie, apparently you've held on to John Bush for a little while longer, but there's some other options out there for you, I think, who would do good service for you, but I regret seeing John get out of the landlord tenant business also. He does a good job in his cases, but I understand why he wants to pull
I've been
back.
trying to twist his arm, but I'd like to maybe get with you.
A local attorney has picked up some of his cases and they're gonna get back in the landlord tenant business, and he might give you some advice on that.
Okay, thank you.
This is a termination of tenancy case and we have service on both. This one is set for 1:35, so it's not for 9 minutes. So I'll put you both in the waiting room until somebody shows up. Have you sit here with me staring into space. In the world's most boringest live stream. All right, we got a little breathing room here. What happened is some of the cases in the middle got settled. We had a 125, a 130. The 130 is done. 135, 145, 50, 55, 2 were booked up until 2:45. Good afternoon. I think I've got everybody I need. I've got Joshua Ferris, Elisa Ferris, Jamie Kreitz, Meg Bauer, and John Bush, number 2.
Why is he in here?
Mr. Ferris, can you hear me?
Yes, sir, I can.
Mrs. Ferris, can you hear me?
Yes, sir, I can.
All right, this is a termination of tenancy case. Mr. Kreitz wants you guys to move. And he served a notice to quit on you in August on the 25th. As a defendant in such a case, a termination of tenancy case, you have the right to obtain counsel for representation in this matter. If you cannot afford an attorney, a legal aid attorney may be available to help you, and we do have a legal aid attorney here with us today, Miss Meg Bauer from Western Michigan Legal Services. You have a right to have the case heard here in St. Joseph County where the property is located. You have a right to demand a jury trial. Wish to have a jury trial, you must tell me at this first appearance or make the demand in writing within 5 days of today, filing the jury demand form, and be prepared to pay the $50 jury demand fee. Unless the judge waives the fee for your inability to pay it. You may be able to reach an agreement with the landlord by going through mediation. If both parties are agreeable to that, a court could help set it up. Or you may be able to reach an agreement that would result in the conditional order of dismissal, and we would assist in preparing that. Probably, if it was such a thing, Mr. Bush would prepare it. The termination of tenancy was filed on August 25th, post the lease period. It's a month-to-month lease. He has to give you at least 30 days notice. And that would be September 5th and then, or 25th. Then we went through October and now November. So that's correct, Mr. Bush. Plaintiff just wishes to terminate tenancy.
That's accurate, Your Honor.
Mr. and Mrs. Ferris, what's your position?
I'm wanting to demand a jury trial.
All right. Ms. Ferris, what's your position?
Yeah, we would like a jury trial.
Do either of you have a law degree?
No.
You know anything about the rules of evidence?
Yes, sir.
All right. You have to file the demand in writing and pay the $50 jury demand fee. Why don't you wish to move? Will you hold still, Miss Ferris? You're making me nervous. This is like watching a episode of a handheld TV camera show.
Sorry.
What's your basis for a jury trial?
All right. So back in 2024, I know that ain't got nothing to do with it now, but Larry decided that he wanted to evict us. Okay, so he told us if we came up with the remainder of the money that we owed him, that it would be dismissed. And so we came up with the money, and it got dismissed. Well, what we didn't know is that Larry told us that we were to pay for the court fees and the lawyer fees regarding the 2024 eviction. And so we paid that to him. And I was
at
told
this
that,
point, he's not asking that you pay anything. He's just asking that you move, and
Yes,
has been asked that you move since sometime before August 25th.
Can I speak?
Yes.
We have 3 kids and we're getting into winter months, and the housing resources, we're working with Neighborhood Inc., but the housing resources are just not there. Like, we're looking for a place, we're trying to move, but Neighborhood Inc. is in the process of helping us, but they've sent us a whole landlord resource list for private landlords, regular landlords. We filed at Village Manor. There's a year's wait list. That's the reason why we want to fight it. One is because we have children and we have nowhere to go.
Yes.
All under the ages of 12.
Well, the first thing we need to do is continue this matter for Ms. Ferris. Why can't you stand still?
Because I have really, really bad anxiety.
All right, well, we'll try to do the best we can. If I do grant a jury trial, I'm going to do an escrow order. So you're going to have to pay the rent to me, and I'm going to hold on to it. You don't just get to live there free for months while this matter gets set for a jury trial. So you're going to have to pay your rent to me, which will be less rent you would have to go to another place. And I hear this every week. People would say we would move out if we had somewhere to move to. And when you say reason for leaving last property evicted, after jury trial, no one's going to want to rent to you. So it's already hard enough to find a place to move to. So the first thing we need to do is continue this matter for at least 7 days, which will take us to next week. People would move if they had somewhere to move to. But you're not a very good risk because your current landlord's evicting you for not paying the rent. They don't want you as a tenant anymore. So the next landlord may not want to take a chance on it. If you could get into one of the subsidized places, that would be good. But you're right, there's a waiting list on all of them. So you're asking for a jury trial to delay it, which it would do, but I'm not going to delay it till January, February without you paying the rent. So you'd have to pay November, December, January, and February's rent, or whenever we could set it. We have a bunch of criminal cases that also wish to have a jury trial. We haven't had a jury trial since I've been here. And maybe we had one when Judge McManus was here. So, Mr. Kreitz, what is the current rent?
I do not have that with me, Your Honor, as we weren't going after
Yeah.
the rent. I would have to
Well,
get
let's
that
look at
to
the
you.
lease. That'll give me a clue here.
Hey, Your Honor.
Yes.
And to also talk to you about the lease. Okay, Larry also bumped up our rent. I want to say it was the following last year. So the amount that says that we have to pay him on a 185, that isn't correct because we've been paying more than 185 a week. And that's because before everything was said and done, we paid Larry, I want to say it was $10,200 back in
August.
before the eviction got filed. So I just wanted to let you know.
Was that with financial help?
Pardon?
No, we sold our brand new car for it. We sold our brand new 2018 Jeep Compass to pay our rent here because Larry told us if we did that we would have a place and a roof over our kids' heads. So we sold our brand new Jeep in August of this year for $12,000 and we gave him everything
in
we
August
had.
of 25?
Yes, sir.
Well, then he served a notice to quit on you on August 25th.
Yes, that's correct.
And that's what we did. That's what didn't make no sense to us.
Our representative from Legal Aid is here, and you may wish to speak to her. Let's continue this to next Friday. John, are you available next Friday?
It depends what time, Your Honor.
10:15.
I should be. I have a misdemeanor pretrial in the morning, but I'll be with a few feet from you.
All right. Let's make sure that time is available. Yes, I have 9:40 and then I don't have anything till 11. So we'll continue this to 10:15. Meg Bauer from Legal Aid is here and she's willing to meet with you right now. and at least get contact information, so you can discuss it further. So your car was sold in August of 25, not August of 24?
Yes, sir.
Correct.
All right. All right, let me put Lisa Ferris into room 1. Josh Ferris into room 1. And legal aid into room 1. All right, Mr. Kreitz, Mr. Bush will address this further next week. Meg, are you in the room? There we go.
Jamie, I'm going to call you in just a few moments, okay?
Okay,
All right, very good. I'll see you next week.
Thank you, Judge.
thank you, Your Honor. Enjoy the weekend.
Yes, enjoy the rainy, cold weekend with snow. All right, we have the alleged Matthew Davidson here. He has a couple of cases.
Well, no, like impressive. Yeah. There should be some right there. There's some up there in the desk. Oh, you see there.
Good afternoon, Mr. Davidson.
Hello, Your Honor. Happy Friday.
Thank you.
In fact, Your Honor, you've worked so hard this week. Why don't you just take off the next couple days?
Thank you. We have had a busy day today.
You got 4.
You got a couple of matters. Our next one isn't set till 1:45, so we need to let the clock tick a couple of minutes.
Well, also the 145 and the 155 are the same.
Yes,
There's 2 different units in the but same plaintiff, same defendant. So
I'm familiar with this property. Mr. Deerduff had other people living in there, and there were problems with this property, and
my only point was if you wanted to do them together, we could do them at 155.
well, I need to get both parties here, I guess.
Fair enough.
We'll see who shows up first.
Yeah, I don't know if you can see it, but Bruce Butch Baker's here, representative of Heartland.
Heartland Rental Properties is the current owner. Who did you purchase this property from?
You're asking me, Bruce?
I can't hear you very well.
Hey, speak up.
Yeah, that was a while back. My son and I bought it, and then we split up our LLC.
Who did you buy it from?
All right, was this the property that had the motorhome parked in it and a bunch of other people in it?
There's been quite a number of civil or city infractions while Carrie Deerduff was in charge of buying it from my wife and I.
All right, well, let me look at this for a minute while I'm waiting.
We bought it from Crystal Heveland, if that name means anything to you. My wife and I did. Or maybe my son and I. And then we ended up fixing it up and selling it to Carrie Deerduff, Mr. Carrie Deerduff.
Yeah, I had several cases with Mr. Deerduff doing evictions, but you're telling me he didn't even own the property?
He was buying it on land contract.
Okay.
And
yes.
He paid his payment, but he got behind on other.
All right, I can't hear you very well, so let's just wait.
On insurance and taxes and.
All right, just stop. He's not here yet, so we need to wait for them.
Okay.
All right, so yeah, he kept getting people in there and evicting them, and
he has since quit claimed his land contract interest back to Heartland. So he did have an ownership interest. He does not now.
All right. That helps. My cousin lived at 116 West Bennett, and I spent a lot of time in that neighborhood. That was an apartment building even 50 years ago. It's got nice income potential if it was managed better. There are people looking for housing all over the place. And it was just falling into disrepair, and he had junk all over, and so it wasn't good. Here's somebody by telephone only, which isn't ideal.
His number. It carries number.
All right, somebody's here by telephone. Who am I speaking with?
Mark Parker.
All right, thank you.
You're welcome.
Do you have the ability to come in by something other than telephone?
He's on the next. Sorry.
What's that?
All right, well, just stay where you are.
Okay.
We'll do the best we can.
I just don't have data on my phone, so it's
I recognize that.
All right, here's Mr. Macknick and Ms. Patel. We're not quite ready for you guys yet. Good afternoon.
Good afternoon, Judge.
Welcome to 3B District Court. We're in hurry up and wait mode, waiting for some defendants that are supposed to be here but are not. Your matter's set for 2. We're probably going to get to it early. We don't have personal service on Mr. Deerduff. Mr. Parker, I'm going to mute your phone. The problem is you may not be able to unmute it. You've got wind background noise or something. Let's see how that goes if you can just hold still. Okay. All right. We started at 8 o'clock this morning, and I took a 12-minute break from 12:48 to 1, and we started over again at 1. So we're getting our money's worth today. Let's talk about Heartland versus Deerduff. This is a termination of tenancy action. I learned that Heartland Rental has taken the property back with a quitclaim deed. Mr. Deerduff had several landlord-tenant actions under his name. Because I don't have personal service, I can't do a default. Do you believe he's still in the premises?
No, he moved down to his daughters in Indiana. His people are in there though.
All right.
Yeah, he hasn't been there for a while.
Are there people in his unit?
Yes. Our eviction.
All right, it's Kerry Deerduff and all occupants.
Right.
Well, here's.
Bruce made multiple visits and posted it according to.
Yeah, this property needs to get cleaned up. They need to get everybody out of there. They need to clean it up. I said it's could be a nice place with a lot of income potential, but right now it's about a half a step from being condemned. All right. Well, we have to continue the matter because we don't have personal service. So I'm going to continue it to next Friday, November 14th at 10:20. Does that work for you, Mr. Davidson?
I think, wait a minute. Let me just double check. Because there is something going on next weekend I can't remember. It actually doesn't work for me, Your Honor.
Would another time work?
No, I'm gonna be leaving Thursday afternoon for Traverse City.
All right, well, how about Monday,
For
the following
basically
Monday?
the-
What?
Excuse
Does
me?
that work?
My daughter was born on opening day, so I've got to be up there for the 15th.
All right, some things are more important.
Well, it's on
Let's
my
see what we
schedule.
got here. So will you be here Monday, the 17th?
Yes, I could be.
2 o'clock, Monday, November 17th.
Thank you, Your Honor.
Now, our next matter,
Oh,
Heartland.
are we done with Butch Baker, Your Honor?
Yes, but let's take up Danny Lalonde. I've got somebody else in the waiting room. Shauna's early. All right, Daniel Lalonde in apartment A is set for 1:45, and he's not here either. And we don't have personal service on him.
Who's Daniel Lalonde?
He's the tenant. Okay. Unit 1.
So we're gonna do the same thing. With Lalonde. Well, these both say Deer Duff. Continue.
Yeah, I think the situation with Lalonde is he had accepted, Bruce served him.
All right,
But he
we'll
was
continue
just
this
to. They're all shirt tails of Carrie Deerduff.
11/17/25 at 2 p.m. You got a lot of unknown tenants in there, need to get out.
That's our goal.
Like I said, this could be a nice rental with lots of income stream, but right now it needs to get cleaned up. All right, Mr. Davidson, you have a nice trip. Sir, I'll see you a week from, well, Monday, 10 days from today, on the 17th, and we'll address both of these matters at that time.
Thanks, Your Honor.
All right, thank you. All right, and we got another Matt Davidson case. We have a lot this afternoon also. We thought we would try to get our real money's worth. All right, let's see who we got in the waiting room. We got John Williams, Erica's phone, Paul Mayers. And we got a slate that looks like the gallery from the Muppet Show.
There we go.
All right, let's see if we got all the partners. Hello, Mr. Williams.
Hello, how are you, Judge?
Nice to see you. I'm very well, thank you. We need Mr. Davidson to come back. There he, no.
Yeah, I don't know what happened to my video. I'm trying to figure it out, Your Honor.
All right, let me call it.
I wonder
This
if
matter is entitled John and Lorraine Williams versus Mark Hart and Johanna Green. Johanna Green is here. Are you Mark Hart?
Yes, sir.
All right. Mr. Matthew Davidson is representing Mr. and Mrs. Williams, who are present. The defendants are both present. And Jason Macknick of the firm Macknick, and Macknick, you should put your name first, is here on behalf of the defendants. And this matter is not straightforward and clear cut. It is filed as a land contract forfeiture. Mr. Davidson filed the action on behalf of the Williams. Mr. Macknick filed an answer and has a different view of matters. Mr. Davidson, what's the status here?
Yeah, I want to clarify the record. This is a lease and it was filed as an eviction.
Well,
recovery possession. And
let's take a look.
The defendants.
Oh, yeah, it is filed as a termination of tenancy rather than, they claim it is a land contract. It's a lease option to buy.
It's not a land
And
contract.
sometimes determining the difference between a land contract and a lease option to buy is the difference between Saturday night and Sunday morning, trying to figure out where the line is. But it's entitled Personal Home and Property Lease and Purchase Agreement, March 21st, 21 through March 28.
The answer is, Your Honor,
so,
that the term, I'm sorry, Your Honor, I'll listen.
Go ahead.
Well, the answer is that the terms of the document are a lease. It's not it's a house with significant acres for $1,400 a month. It's a lease. It says it's a lease, and while it does give some purchase option to the occupants, it is not a land contract. The land contracts are land contracts. It's not a land contract. There's no interest. There's no, it's just not a land contract. If the parties paid everything that they were supposed to pay, they could indulge in a purchase agreement, but they have not. The defendants have not paid since May.
Your Honor, if I may respond and with a preliminary thing, I'm accompanied here by Miss Patel, who was sworn into the Michigan State Bar last evening, I guess, at 4 p.m. I'd love to have her be able to participate, but I do not have a P number for her. I did the swearing in myself on behalf of the Kalamazoo Bar Association as its vice president, and did the actual swearing in the motion myself of her. So if this court would permit her to present on behalf of the defendants, I would appreciate it, but I am prepared to go forward myself.
I defer to the
No, your representations are satisfactory. Congratulations, Ms. Patel. The pool of applicants taking the bar gets smaller and smaller, and the pool of people actually passing the bar smaller yet. So congratulations to you.
Thank you. Dad.
Where are you from originally?
Here, actually, Kalamazoo.
Oh, very good. Where'd you go to law school?
Loyola University, Chicago.
Well, that's where Judge Stutzman went. That's done all right for him. All right.
That's
What's your
great partners along the way?
Yes. Well, so we have what Mr. Davidson claims is a action to terminate the tenancy and have them move. Your representation by your pleading is it's something other than a lease option to purchase. What's the defendant's position?
Yes. So just to clarify, Judge, is it all right if I present?
Yes, that's acceptable.
Okay, perfect. So, Your Honor, we're here today because opposing party does believe that this is a lease. However, this is a land contract. This is a substance over form argument. You can see that they have had installments and to a final payment that they will end up getting the full legal title as well to the conditional equitable title to the property. This is different than a lease because even though it uses the words lease, this is created by lay people that do not know the legal definitions of a land contract. I'm sure that's what the intent was. So for example, I know opposing party did say that this was a lease to purchase with an option to purchase. However, if you have the document or the actual contract in front of you, in section 5, it does say that once they make that final payment, that lump sum, that they will be signed over the property. There is no option here. That is what a land contract is. So it's not a lease to purchase, and moreover, it's not an just a regular lease because they do have equitable title to the property at this moment. And then moreover, at the end, even though it uses the language of in the very last little paragraph that Hart and Green agreed to immediate eviction for the non-payment of lease, that is just what lay people say instead of a forfeit for a land contract, because they are paying towards that final contract price. But then they are forfeiting essentially if they do not pay. We're not here because we don't contest that Hart and Green haven't paid. We're here because this is a land contract just done with layman's terms instead of using like actual land contract terminology. But that is the substance here. And moreover, the plaintiff did draft this lease, so they do have contra preferendum, like it is construed against the drafters, which are the plaintiffs in this side, and this is a land contract. Moreover, we're just asking for this court to dismiss the case because it's not an eviction landlord tenant case. They have more rights. They have a different set of rights than under the Michigan law. However, just Your Honor, in an effort to be flexible and more efficient, and because we are aware of your court's very busy schedule and your 12-minute lunch, that
it isn't like that every day, but today was
that opposing
busy.
party just amend their complaint to reflect the correct legal proceeding for a land contract.
All right, there's some things that aren't in here. As I said, it's entitled Personal Home Property Lease and Purchase Agreement.
May I speak, Your Honor, please?
Yes, but I have a question. Who's paying the taxes?
It is.
I'm asking Mr. Davidson. Can you tell me who's paying the taxes?
Mr. Williams, could you answer the question, please?
We are.
The owner.
All right, so the plaintiffs are paying the property.
Pay the homeowner's insurance.
They pay the
They
taxes.
pay taxes and homeowners insurance?
Yes.
Correct.
And,
that mitigates toward the fact that this is a lease option to purchase rather than a land contract. The plaintiff filed a memorandum, or the defendant did, which they cite a statute and some case law. Plaintiff hasn't had an opportunity to respond to that.
I would do so now if I could.
And so, Mr. Davidson, what's your response? So in a land contract, the purchaser is generally responsible for the taxes and insurance on the property. In this case, the plaintiffs, according to them, nobody's under oath, but their representation is that they're paying the property taxes and the homeowner's insurance, which make this appear to be more of a lease. We get lots of these. A lot of mobile homes are lease option to purchase. A lot of other things are lease option to purchase. And often they're self-drafted, which leads to some ambiguity. Mr. Davidson, you wish to respond?
Yes, I appreciate Ms. Patel's attempt to describe what happened, but she wasn't there and she's not correct. The plaintiffs specifically chose not to do a land contract. This wasn't an accident. It wasn't something they are not, they didn't just crawl out from under the